This case is related to the Chapter 1, which is the relationship of bankers and customers. So, I will explain about the definition of the banker and customers. The definition of bankers is the person which carries on banking business, which include the business of receiving deposit in any currency or deposit account, which is deposit account are current, fixed deposit account, saving account, or other similar account. Second is paying or collecting check drawn by or paying by customer. Third is providing loans and advance to customer. And lastly is allow any provisions by the Ministry of Finance. While the definition of customers is a no statutory or legal definition, or known as a person who has an account with the bank.
So first of all, the rights of banker. Banker has the right to charge reasonable remuneration, or in other words, charges for its services such as interest on loans. The banker has the right to set off or combine accounts customer but cannot set off debit balance in loan account against a credit balance in deposit account. After that, banker has the right to use customer money with it wishes, such as giving loan. Banker also has the right to be indemnified when carrying out of service for customer if loss incurred. Furthermore, banker right to be repaid on demand for an overdraft and right to expect the customer to take due care when issuing checks. And lastly, bank may claim a right to a lien over a customer property coming into its hands in the normal course of business and including checks lodged for collection. So that's for banker rights. Now I will brief about customer rights. Customer also has rights such as right to be supplied with a statement or passbook to maintain a high degree of accuracy in their bookkeeping. Then, customer also has right to be repaid the balance standing to the credit of the customer accounts and has right to interest his deposit accounts but not on his current account. And lastly, the customer has rights to appropriate payments made to any of the accounts as he likes, where he has two or more borrowing accounts.
Now I will talk about the facts of the case. Siegfried Joachimson, Jacob Joachimson, and L.E. Mark operate a business as a partnership. L.E. Mark is a British citizen and the other two were German nationals. The firm opened and operated a bank account with Swiss Bank Corporation. On 1st August 1914, Siegfried Joachimson died. Under English partnerships law at that time, this had the effect of dissolving the partnership. However, 3 days later, World War I broke out, and Jacob Joachimson returned to Germany. The firm's account with the bank was dormant for the duration of the war. The case report suggests that this might have been because of legal prohibitions relating to property of enemy aliens. After the war, L.E. Mark tried to win up the affairs of the partnership and sought repayment of Euro 2,312 held in the bank account from the bank. The bank refused to repay the sums in the account, arguing that either the firm had made no demand for repayment of the sums and so they were not due, or in the alternative that if the right to repayment arose upon the death of Siegfried Joachimson, then it was now backed by the statute of limitation. The case report indicates that there was a great deal of procedural wrangling at first instance in relation to whether the claim could be brought by an individual party or had to be brought in the name of the firm.
For the case explanation, This case is about the fundamental nature of the legal relationship between bankers and the customers. Was the issue of a judicial decision by the Courts of Appeal of England and Wales. So, in this case, the bank is under obligation to repay the money of the customer unless the customer make a demand. For example, the customer will fill in the withdrawal form or using the check to take out the money. Then, the bank obligation to pay is conditional upon the check being issued in proper form, like there is must not make alteration in the check. Other than that, the bank has promised to repay is at the branch where the account is kept. For example, the customer is not allowed to withdraw the money at any other branch. And lastly, customers must have sufficient funds in their account for the bank to make the payment. An example, the customers cannot withdraw the money more than what they have in their account.
So now, I will explain about the court held for the case. According to the case report, there was a lot of procedural wrangling at first instance about whether the claim could be brought by an individual partner or had to be brought in the name of the firm. The Court of Appeal held unanimously that the claim was not statute barred until a customer demanded repayment from the bank. The debt was not due and payable, and thus limitation periods would not run.
A customer could bring an action for the credit amount of his account before he first made a demand for its repayment. The bank's first indication that the customer wanted his money returned would be the service of a writ of summons. So, the court declared that the implied term of the relationship which exists between the bank and current account customer is that the demand should be made first for repayment before the debt become due. That is, the debt is not due until the customer has made a demand upon his bank for repayment of the deposit of part of it. In Joachimson's case, the plaintiff acting on behalf of his firm were make no demand for repayment of the balance of current account held by the defendant before bringing an action to enforce repayment. The court then dismissed the proceeding. A course of action only arises when the demand has been made and it is dishonored. In delivering judgment in this case, Atkin LJ pointed out as a result of the court decision, the statutory time in which to bring an action for repayment of the deposit does not run from the time the deposit is made, but rather from the time a valid demand is made for repayment and it is refused.
Next, I will conclude about this case. The point decided in the case was that a customer does not have a right of action against its bank for repayment of sums until the customer makes a demand. And accordingly, for the purpose of limitation periods, that time does not run until such a demand is made. However, the reason the decision is considered so important is for the influential comments made by way of bitter dictum by Atkin LJ in relation to the nature of the banker-customer relationship. The case is also cited as the leading authority for the proposition that a demand for repayment must be made at the branch of the bank where the account is kept, like a position which appears increasingly anachronistic in modern banking. That's all from us. Thank you.